In my humble opinion, this is the biggest COVID decision to come out of Canada, period.
And I only found out about it yesterday.
Viva Frei, former Montreal litigator turned current Florida rumbler with, get over here, Winnie the Westie, who's bothering me this, oh, he's going down, who's bothering me this morning, so I took him into the car to do the vlog. You happy? You look happy. Okay, go sit down. This is hands down the biggest decision coming out of the courts of Canada as relates to striking down COVID measures, period, full stop. And somehow I only found out about it yesterday when I was interviewing the lawyers who just filed the biggest class action lawsuit against the province of Alberta as a result of this decision. Now, for those of you who don't know, the Alberta court over the summer at some point declared Dena Hinshaw's public health order directives as relates to shutting down businesses, limiting gatherings, etc. The court declared her public health directives, whatever the hell you want to call them, ultra-virus, meaning unlawful, meaning they are all as if they never existed, struck down. Dena Hinshaw exercised her authority in a manner that exceeded the limits of the law, specifically because she was not the one making the public health directives. She was just offering a slew of options to the politicians, Kenny in particular, who would make a political decision, whereas this had to be a medical decision because that's what it was supposed to be under the law. Now, before we even get into the decision, I'm going to give a brief overview of it because it's a long decision, it's complicated, and there's a bit of a legal peculiarity to it because the court came to the decision that Dena Hinshaw exercised her authority in a manner that was ultra-virus, but that the measures would have been constitutionally justified. I'll explain it in a second. But for those of you who might have forgotten who Dena Hinshaw is, she is a raging psychopath.
Good morning, everyone, and thank you for coming today. And I will now turn the podium over to Minister Lagrange.
Thank you, Dr. Thank you, Dr. Hinshaw, and good morning to everyone.
Thank you. Good morning, Dr. Hinshaw. You said in your comments that 8 times more children were hospitalized for anxiety disorders than for COVID during these past 18 months. Was this as a result of the lockdown, their health measures? And how does this differ from previous pre-COVID years? Do you have any hard numbers on that?
Thank you for the question.
Now, as far as I am concerned, it's relatively clear Dena Hinshaw is either a psychopath, she's either a paid actor, or she is suffering from some form of mental issue. And I say that without judgment. If she is suffering from some form of mental issue, that's fine, but she should not be making medical decisions based on her clear, undeniable, and clearly manifesting mental illness. And it's not just that she is a mentally ill psychopath, in my humble opinion, she's also a pathological liar. Dena Hinshaw is the woman who lied about the death of a 14-year-old Alberta boy, claiming that he was the province's youngest COVID death. Well, it turns out that the boy had stage 4 brain cancer, apparently was in a coma, and they decided to test him, and he tested positive for COVID, and they then claimed that he died from COVID. Well, Dena Hinshaw, after lying about the death of a 14-year-old boy, came out and apologized for it shortly afterwards. So that is the refresher as to who Dena Hinshaw is, who was purportedly making these wildly unscientific medical decisions to shut businesses down, limit public gatherings, indoor and outdoor. That's the woman behind all of the decision making, but not so much because apparently she wasn't the one making the decisions. From City News Calgary, Alberta violates Public Health Act. Hinshaw not decision maker on COVID recommendations. Judge. Posted August 1, 2023. An Alberta court decision Tuesday says former Chief Medical Officer of Health, CMOH, Dena Hinshaw, did not have the final say regarding COVID-19 health recommendations. Justice B.E. Romaine released the 90-page decision, which includes the province and Hinshaw as the respondents, and Rebecca Mary Ingram, Heights Baptist Church, Northside Baptist Church, Aaron Blacklaws, and Tori Tanner as the applicants. Quote, the Public Health Act requires that decisions with respect to public health orders must be made by the CMOH or her statutorily authorized delegate. The final decisions implemented by the impugned orders in this case were made by the Cabinet of the Government of Alberta or by committees of Cabinet, end quote, the decision reads. Now, why is this decision only now coming on my radar some August, September, October, November, December, January, February, 6 months late? Good question. Yesterday, I interviewed Jeff Rath and Eva Chipiak. Those are the lawyers who just filed the largest class action lawsuit against the province of Alberta, and they filed that class class action lawsuit as a direct result of this order declaring those public health orders ultra-virus, meaning unlawful, because they now have basically the judicial basis to go sue the province for the damages caused by those unlawful orders. They were the law firm behind this successful petition to the courts. They call it the Ingram decision. They were the lawyers who successfully got this Ingram decision, and I'm like, holy crab apples, I've got to do a short vlog summarizing the Ingram decision so that people understand the judicial context before I publish our interview. And by the way, stay tuned, I'm publishing that interview later this afternoon. And this is the Ingram decision, the decision that declared Dena Hinshaw's public health orders ultra-virus, because ultimately the decisions were not being made by the medical officers, they were being made by the politicians after a list of options were given to them by the medical officers. Bottom line, this was all willy-nilly rubbish. Quote, while the CMOH made recommendations and implemented the decisions of the cabinet and committees through the impugned orders, she deferred the final decision-making to cabinet. Although Dr. Hinshaw was maligned during the pandemic and afterwards as the symbol of the restrictions, she was not in fact the final decision-maker. The delegation of her final decision-making authority to cabinet is not permitted by Section 29 of the Public Health Act, end quote.
Good morning, Dr. Hinshaw. You said in your comments that 8 times more children were hospitalized for anxiety disorders than for COVID during these past 18 months. Was this as a result of the lockdowns or health measures? And how does this differ from previous pre-COVID years? Do you have any hard numbers on that?
Thank you for the question.
Appreciate what this decision is saying. This decision is actually saying the people who were saying trust the science, follow the science, were themselves not trusting the science or following the science. They were following the politics. The chief medical officer of health, who was legislatively empowered to enact certain guidelines, was in fact not doing it. She was just providing a list to the politicians who were selecting the most politically expedient solution. In other words, it wasn't science at any point. It was politics all the time. But the decision goes on to offer a bit of a quirk, saying that although they have declared these public health orders ultra-virus, meaning it exceeded the scope of the legislation that empowered Dena Hinshaw to make the decisions that she wasn't making by deferring them to politicians, that had they been lawfully made, they would have been deemed not unconstitutional because, you know, it totally makes sense that we're not violating charter rights by locking people in their homes, shutting down their businesses, limiting the sizes of their gatherings. That would have been totally reasonable under a free and democratic society by way of restrictions of charter rights, but they didn't do it the proper way. Romain's decision continues, saying had Hinshaw enacted the impugned orders, they would not have been unconstitutional. Quote, while they may have infringed certain of the applicants' rights under the Canadian Charter of Rights and Freedoms, being Schedule B to the Canada Act 1982, UK 1982, Chapter 11, and the Alberta Bill of Rights, RSA 2000, CA 14, these limitations were amply and demonstrably justified as reasonable limits in a free and democratic society pursuant to Section 1 of the Charter, and that they were enacted pursuant to a valid legislative purpose, end quote, she said. Quote, in conclusion, I declare that the impugned orders were ultra-virus of the Public Health Act because they were based on an interpretation of the Public Health Act that gave final decision-making authority over public health orders to elected officials, end quote. And from what I understand, as was explained to me by Jeff Rash and Eva Chipiak in the interview that you're going to see shortly, Danielle Smith, the Premier of Alberta, has decided not to appeal the decision, so the decision is final and binding in law. Hence the legal basis to now file the largest class action lawsuit ever against the province of Alberta for the damages resulting from these ultra-virus orders. Now, some of you might be saying, oh, this case is specific to the province of Alberta. It's very fact-specific. I say it probably has a more national import to the other provinces that some might think, because I have a sneaking suspicion all of the public health orders in all of the provinces were established on a willy-nilly and probably equally ultra-virus basis. What was the statutory legislative authority of the public health officers in other provinces when they were making their own recommendations? Did they go through an equally political and not scientific procedure? Was it actually politicians making the decisions and not the public health officers who may have been legislatively empowered to make those decisions? I have a sneaking suspicion if this was done in one province, it was done in other provinces, and it might be worth challenging the public health orders in other provinces on a similar basis. You know, when you have Horacio Arruda, the public health officer out of Quebec, coming out and literally saying that there's no scientific basis to justify a curfew to combat a virus, you might want to ask yourself, who the heck is making the decision? Is it a public health officer or is it a purely political decision?
Why are you threatening people taking walks in the evening to get a fine? What will that change in the fight against COVID? The measures that we set up for COVID are cumulative. There is no science that can tell you that such and such a measure will have such and such percentage of efficacy.
And following this ruling out of Alberta, if it's a purely political decision, did the politicians have the authority to make those decisions? Anyhow, to be determined, but this is one heck of a smashing decision coming out of Alberta. The consequences are going to reverberate far and wide, and I can't wait to see the outcome of the class action lawsuit that is being filed against the province of Alberta. And for a breakdown of that, be sure to like, share, subscribe, and watch the next video, which is going to be my interview with Jeff Rash, Eva Chipiuk, explaining their class action lawsuit against the province of Alberta. It's amazing, but more important than any of that, get outside, exercise, eat healthy, talk to people in real life, make sure everyone around you is doing well, and now you know your vlog. Peace out, peeps. Booyah!
And I will now turn the podium over to Minister Lagrange.
Thank you for the question.